You know, I think if you'll indulge me a little bit, I'm going to try and get to the takeaways first because that may be an interest that is... let me see if I can go backwards. Can't. A good deal of this presentation has already been covered, so I think it would be interesting to get to the takeaways before we get into some of the detail. Okay, takeaways. You know, and following up on something that was in Abu's presentation just now, he said, don't rely on self-reporting regarding the TNCs. That's an important point. Just recently, within the last few weeks, well, a background point on this, when the California Public Utilities Commission adopted regulations for the TNCs, the Cal PUC set up a self-reporting mandate whereby the TUCs had to report their data to the PUC versus the adoption of an application. That resulted in a year of, to be frank, rigmarole and stonewalling from the TNCs. And the PUC, for example, recently fined Uber $9 million for failure to comply with its self-reporting obligations. So I think that's a very interesting takeaway point on those issues. Now, what are some other important takeaways? It was interesting to hear Mr. Bird speak of what Uber's strategy is, or what the TNC strategies are, and they are to get market share. A major Achilles heel on that drive to get market share is the first takeaway, which is the TNC business model is threatened by misclassification litigation that could transform its drivers into employees. Lobbying efforts to combat this are ongoing. But what are we talking about the magnitude of the litigation? In California alone, against Uber, for example, there's one case where the potential liabilities for misclassifying Uber drivers as independent contractors when there is tremendous evidence indicating employee status is about $500 million, somewhere between $400 and $500 million. I'll get into some of the details on that later, but that's an important takeaway, that there are substantial threats to the stability of this business model, and part of its goal is to, as Dave said, get market share very rapidly and entrench itself. We all know that currently the TNCs have less stringent regulations, although LAX has now required a fingerprinted background check. There are also other types of lawsuits that are cropping up against the TNCs, which I'll get to, which, for example, discrimination against folks who are blind because the TNC applications are not user-friendly on the cell phone to somebody who's blind, in contrast to the traditional taxi and shuttle industries, which have effectively compliant terminals and systems for folks who have handicaps. Now, with getting through those takeaways, I'm going to go back, if you'll indulge me, and get into some of the specifics of the cases. Okay, and we lead off with our first case. Now, the slide that was about Borrello factors, these are just the California standards that are imposed to determine whether a worker is an employee or an independent contractor. Effectively, they're very similar throughout all the 50 states. But to get into the specifics of the case, the first one involves Lyft, actually. And it's important to note the takeaways that the courts have. The TNCs have followed a unique strategy. When they get sued by a driver claiming that he is an employee, not an independent contractor, they take the position that we're an information company, we're not a transportation company. Uniformly, the judges are taking a reaction that essentially the TNCs have so invasively gotten involved in the work the driver does that they're controlling the driver like an employee. Now, and something I believe is relatively apparent to the AGTA membership is that if a driver is characterized as, and also the ability of a TNC to charge reduced rates, is that if a driver is characterized as an employee, the TNC's operating costs and therefore fares would probably easily go up by about 40%. So to be able for the TNCs to characterize their drivers as independent contractors creates a tremendous economic advantage for the TNCs. But in any event, in the Cotter v. Lyft case, it's important to look at one of the bottom takeaways. The court stated in indicating that there was strong evidence of employee status that the requirements that the TNCs impose on their drivers and sort of the invasiveness through that app in the work the driver does, it doesn't seem like Lyft gives voluntary suggestions, but these appear like orders that the drivers have to comply with. And once you cross that line from the independence of the operator to orders and control of this nature, you risk an employee finding. The major case against Uber, and this is the primary case everybody is following, is O'Connor versus Uber. Interestingly, the lead counsel on this case is a lawyer who recently obtained $228 million against FedEx, and in many ways was responsible for driving Federal Express out of characterizing its drivers as independent contractors. So these are real suits with real teeth. In this case, Uber, as often happens, filed a motion for summary judgment, which is a motion asking the court to make a firm ruling that the drivers are independent contractors, not employees, before the case ever gets to trial. I think any legal observer would say this was a dramatic to resounding defeat for Uber because Uber invited the court to pass judgment on its model. The court denied the motion claiming independent status and rather forcefully said that there's strong evidence that Uber is treating its drivers like employees. Also, in this case, Uber attempted to make the argument that we're just an information company, we're not a transportation company. That was soundly rejected by the court. That position has been soundly rejected also by the California PUC. In the O'Connor case, the court concluded Uber exercises significant control over the drivers, that it claims a proprietary interest in its drivers, in the riders that Uber provides to the drivers. And this is in contrast to your traditional shuttle and taxi companies where effectively it's the taxi driver or the shuttle driver who has the relationship with the passenger. And these are some of the details of why the court was inclined to indicate that Uber was exercising employer-like control over its drivers. It prohibited effectively what you call personals or independent arrangements between a driver and a passenger so that you can bypass either the taxi or the shuttle company. The Uber handbook has these zero tolerance practices whereby if a driver solicits business from a passenger, you're going to be kicked out of the Uber system. Taxi and shuttle companies don't do this with their drivers. They give them a great deal of leeway in developing private business. This is some more sort of in-the-weeds detail you can get from the presentation when it goes up online about the O'Connor case. Now, interestingly, there have been a number of cases in California that have recognized the independent contractor status of shuttle drivers and taxi drivers. And so there's a distinction between TNCs and the way they control their drivers and the way shuttle companies and taxi companies have a relationship with independent contractor drivers. One of those cases is Ravenel. In Ravenel, one of the factors that is pretty common with the shuttle and taxi services is that they do not go further than the government regulations for the airport, for the city, etc. So you don't have the company taking a proprietary interest in the work of the driver. So the shuttle and taxi companies impose essentially the government requirements and nothing more. That is a key factor that allows these services to remain with an independent contractor basis. these are other factors here. I think go to the next slide. This factor here, the drivers decided when they wanted to work and whether they obtained fares from RPM's dispatch, etc. An interesting distinction, again, shuttle and taxi versus Uber, is that if an Uber or, I believe, Lyft driver declines a certain number of fares, they go down to a low priority list, or sometimes they get knocked out of the effectively a dispatch system. You don't have that with shuttle and taxi, where shuttle and taxi drivers can essentially reject any inbound fare to the airport. Of course, if they come to the airport, they have the obligations under the airport regulations to take the next passenger. But again, these are distinctions between the two sectors within the industry. A taxi case very similar to Ravenel is Ghani versus South Bay Yellow Cab. The driver was paying a flat lease. He could pick and choose when he worked. There was no sort of system that if he declined fares on an inbound basis or out within the city, not necessarily airport transportation, but fares in general, there was no penalization for declining fares, etc. Now, again, I think sometimes it's best to look at these factors later because it is very in the weeds. But in the presentation, well, actually, this is an interesting case. This is the Berwick case versus Uber, and this is the one that hit the New York Times and the Washington Post about 2 to 3 months ago. Now, this was a appeal of a labor commissioner hearing where the California Labor Commissioner determined that the Uber driver was in fact an employee. And what you see here are factors that were cited when the Labor Commissioner concluded employee status. Now, another case where I mentioned earlier where other groups are commencing litigation against the TNCs is the National Federation of the Blind of California versus Uber. And essentially the point that the National Federation of the Blind is making is that the cell phone application does not have any features that either through sound or touch allow a blind person or a poorly sighted person to use the Uber application. In addition, when you get into the specifics of the case, there's allegations that the Uber drivers and or Uber itself intentionally do not pick up folks who are blind. I think this is one of the first of many. What you have with taxi and shuttle is you have a regulated system where you have to pick up in economically disadvantaged zones, where the providers have to have a certain number of disabled, capable vehicles, disabled vans, disabled taxi cabs that can carry a wheelchair and items like that. So far in California, the Public Utilities Commission that regulates Uber has not imposed mandatory requirements for handicapped vehicles, etc. And so what you have is a sort of private sector public response to that, where folks who are in the public are alleging discrimination under the Americans with Disability Act because these services aren't being provided to blind and otherwise disabled passengers. Here's another one. Nak Chan versus Uber and Nak Chan versus Lyft. It's kind of an interesting thing where when you apply to become an Uber driver, the fact that they're going to run a background check on you, which is not a fingerprint check but a credit check, is sort of buried in the 31-page agreement. Typically, if a company is going to do that, that has to be in a separate freestanding sort of paperwork where there's an alert that you're going to be checked under the Fair Credit and Reporting Act. We've talked a lot about the distinctions in terms of the safety requirements for the TNCs and taxi and shuttle in California, and you know, it's an interesting issue. Why are Uber and Lyft so opposed to fingerprinted background checks for their drivers? It seems that is something that's relatively commonplace, but there you have it. They constantly resist this basic issue. Interestingly, as Jim mentioned, LA Airport, however, is going to require fingerprint checks for Uber and Lyft drivers. I think I'm repeating something everybody already knows, that if you have a fingerprint check, it's going to be far more reliable than what the TNCs try and sell to regulatory agencies, which is a non-fingerprinted background check. And the reason for that is fingerprints catch, once your fingerprint's in a database, it's going to be found with name changes, poor record keeping, etc., that you don't have with, for example, LexisNexis background check based on perhaps name and address. You're just going to miss quite a bit. Drug testing, here's another perhaps distinction that is worth noting. Oftentimes, the TNCs aren't being required to do random drug testing for their drivers. You typically have that with shuttle and taxi drivers. And I'm going to skip the proposed LAX regulations and then go back to the takeaways. And I think an interesting overall theme for the takeaways is sort of the march of history. The reason taxi and shuttle organizations are regulated as they are regulated is the march of history. The regulations are there because something happened that led regulators to impose a regulation. Because the TNCs are a relatively new sector within this industry, they have an opportunity right now to be somewhat aloof from the traditional regulations that get imposed against the traditional providers. But for example, in San Francisco in early 2015, you had an Uber driver who on New Year's Day or New Year's Eve unfortunately drove through a sidewalk and knocked down a mom and her two children, and there were, I believe, at least one, perhaps two. The mother died. I believe one of the children died and the other child was horribly injured. In the face of this, Uber and Lyft have still insisted that the only time insurance should apply to their operations is if a vehicle has been actively dispatched or a driver is logged into their mobile app. And then the initial arguments were that the driver was not servicing a passenger or on his way to a pickup at that time, therefore there should be no insurance coverage from Uber or Lyft because there was no sort of active trip involved. What I mean by the march of time and the march of history is that eventually there will be enough serious accidents, fatalities, there will be enough consumer fraud where the information that consumers provided to the TNCs is misused. There will be enough refusal to drop off, arguments between passengers and drivers, that effectively the regulations that are commonplace for taxi and shuttle will be imposed on the TNCs. I think the airports have a unique opportunity, as SFO has done in many ways, to analyze this issue very carefully and adopt regulations that are good on a public policy basis. And with that, I will conclude the presentation. Thank you very much.